Raz, raz. No to jesteśmy. Dobra. No dobrze, to myślę, że możemy zaczynać. So, ladies and gentlemen, esteemed professors, distinguished guests, and above all, valued and brave participants. It is with immense joy and great pride that I welcome you to this extraordinary occasion, the first ever international Oxford debate hosted by the Faculty of Law and Administration at Cardinal Stefan Wyszyński University in Warsaw. My name is Marcin Wielec. I am a professor at the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw, and I'm too a member of the Central European Professors Network, scientific, huge and prestigious program carried out by Central European Academy in Budapest. However, before the debate begins, I have a small request. Our academic community received a few days ago very sad news about the death of one of its members, Mr. Professor Mirosław Kurkowski, Dean of Mathematical Department. That is why there is a great request from our community of our university. The point is that during each event that will take place at our university during the time of mourning, honor the memory of the deceased professor with a minute of silence. This is why we ask you to get up from your seats and celebrate a minute of silence in memory of Professor Mirosław Kurkowski. Thank you very much. So, ladies and gentlemen, at the beginning of the debate is a special way I would like to welcome our distinguished guests from abroad. I warmly welcome Professor János Ede Szilágyi, Strategic Director of Central European Academy in Budapest, today as a captain of Central European team. I welcome very warmly too Dr. Katarzyna Zombory, Program Director for Central European Academy in Budapest. Where is Kasia? So, dear audience, I have no doubt this is a historic moment for our Faculty of Law and Administration, our university, as we take a significant step onto the international stage, bringing together brilliant minds from Poland and Central Europe for a spirited exchange of ideas. Today we witness not only the continuation of our academic tradition in the form of Oxford debate, but also the beginning of a new chapter in fostering global dialogue and collaboration. We are honored that this landmark debate is held under the esteemed patronage of Professor Anna Fidelus, Vice Rector of Cardinal Stefan Wyszyński University in Warsaw. Her support highlights the importance of this event, both as an academic challenge, of course, and as a celebration of our university's commitment to the excellence and innovations. Dear audience, the topic of today's debate, equality in an ever-integrating Europe in general terms, is as profound as it is timely. As we address this critical issue, we do so with the understanding that equality is not merely a principle, it is foundation upon which the future of Europe must be built. The fact that this discussion is taking place in such an international and interdisciplinary setting only amplifies its significance. So it is worth emphasizing that this is the very first time in the history of our faculty that an international debate in this scope, of this scope, with teams composed from students and doctoral candidates. This event not only a witness to academic progress and aspiration of our faculty, but also a celebration of a vibrant intellectual spirit and unites us across borders. It serves as an inspiration for future generation of students and scholars, demonstrating what can be achieved through dedications, dialogue, and cooperation. Ladies and gentlemen, today, however, I wish to focus on something even more fundamental: the courage of our participants. It takes immense bravery to stand on this stage, to present your ideas before a critical audience, and to subject your arguments to the scrutiny of your peers and opponents. Public speaking, yes, public speaking, particularly in such a high-stakes setting, is one of the most challenging endeavors anyone can undertake. Yet here you are, not only ready to speak, but to defend your perspectives with passion, logic, and respect for others. The courage goes beyond pure self-confidence. It reflects a deep commitment to the pursuit of truth, a willingness to engage with different viewpoints, and a determination to contribute mindfully to the discourse on equality in our Europe. Let us forget the hard work that brought you to this stage. Countless hours of research, preparation, and collaboration have prepared you for this beautiful moment. I would also like to highlight the remarkable leadership and mentorship of Team Capitans. My humble person, I had immense opportunity and honor expertly prepared the Polish team, and the Professor Janusz Szilagyi, who has guided the Central European team with equal commitment. Today's event is about more than competition. It is about creating a space where ideas can flourish and where the challenges of the present can be met with the creativity and determination of the next generations of leaders. It is also an opportunity to showcase the important work of the Central European Process Network carried out by Central European Academy in Budapest in cooperation with researchers from our university. So, dear participant, as you step onto this stage, now that you are part of something far greater than this debate alone, you are not only shaping the arguments of today, but laying the foundation for the discussions and collaboration of tomorrow. Your courage to take part in this event is a demonstration to your character and to the future leaders you are becoming. Let us remember the Polish pure wisdom of an old saying, old proverb: niech język mówi, co głowa myśli. Let the tongue tell you what the head thinks. These words remind us of the importance of harmony between thought and speech, a value that is at the very core of debate and intellectual discourse. In the words of John Paul II, the future starts today, not tomorrow. Let this event be evidence to what can be achieved when we take bold steps today to create a better tomorrow. Let words be like swords, and the reason be like a shield. Let's the debate begin, and may your arguments inspire all of us. Good luck to all participants. Thank you very much.
Good morning, and I would like to please Professor Janusz Szilagyi to take the floor. Please, the floor is yours.
Thank you so much. Dear professors, dear colleagues, ladies and gentlemen, it is a great honor for us, for the Central European Academy team to be here, to be in Poland, to be in Warsaw, to be in UKSW. I would like to express my gratitude to the organizers, of course, including Professor Marcin Vielec, also Dr. Bartek Oranzsak, and good to see other professors, colleagues among the audience. It is a great opportunity for our Central European Academy to be represented here in the renowned university. Previously, Professor Vielec referred to the situation that is not the beginning of our cooperation, because we already have a kind of history in this, especially connected to the UKSW, to your university. From Poland, we have approximately 60 or 70 Polish professors as researchers in our research activity, in our research, numerous of them connected to the UKSW. What is really important maybe for the audience, for the young students, that the Central European Academy deals with young researchers as well. We have a young researchers project, a kind of PhD project. The Hungarian team represents the community of our young researchers from Croatia, Serbia, also from Poland. In the Central European Academy, there is a huge number of PhD students, 40 PhD students. They are in Budapest. We are really glad that one of them also connected to the UKSW. That is, she graduated here, Julia Staribrat. Nice to see you here. And we're also really glad that her supervisor also connected to the UKSW, Professor Marcin Vielec. Now you can feel that the Polish-Hungarian friendship can be found everywhere in the Central European Academy. What a competition can be here after that. But of course, we took seriously this debate. There was a local competition in the Central European Academy, and my colleagues who are here, they are won this competition, and that is the reason why they are going to represent our ideas, approaches. Finally, I would like to express my gratitude to the members of the teams, and of course to the audience that you are here, and in a given sense you also provide support for us. Thank you so much, and have a fruitful debate.
So, ladies and gentlemen, good morning. I have to say that for past 4 years, I have had the pleasure of presenting rules of Oxford debates. And I must say I haven't grown tired of it. That is first of all. That is also very fast and very strict. So, ladies and gentlemen, here are the rules of the Oxford debate. That is 2 main areas. The first is adoption of unifying regulations in response to current global challenges, and the second is equality as a foundation for cooperation between EU member states and the EU. 2 teams, one is from Poland, one is from Central Europe. 4 speakers each, 2 minutes for each speech, and each area has 4 specific issues, and each specific issue is presented by 1 speaker from 1 team. Speeches are presented alternately, and the order of speeches is decided by the host of the Oxford debate. Ladies and gentlemen, what I can say more, the rules of the Oxford debate have been presented, and from my side, I wish the participant the best of luck and the audience a lot of pleasure. Thank you for your attention, and I would like to pass the floor to Julia Staribrat, the host of our Oxford debate, please.
Thank you so much, Bartek. So we will, technical issue, wait a second. Okay, so good morning, ladies and gentlemen, distinguished guests and esteemed participants. It's both an honor for me and a personal milestone to stand before you today, especially as I return to the university in a new role as a graduate and also like PhD student at the Faculty of Law at the University of Miskolc and junior researcher at the Central European Academy in the Budapest. So to begin, I would like to introduce the teams participating in today's discussion. So starting with the Central European team, I'm pleased to introduce the head of the team, Professor János Ede Szilágyi. Professor serves as the strategic director of the Central European Academy, and it's also professor in the Faculty of Law at the University of Miskolc. Continue with the Central European team. I am honored to present esteemed members. All are from PhD students and the Faculty of Law at the University of Miskolc and junior researchers at the Central European Academy in Budapest. Jovan Zivanovic is from Serbia. He graduated from the Faculty of Law at the University of Kragujevac. He achieved scholarly pursuits at the scrutiny of the EU private international law and legal dogmatics, while his wider fields of observation comprise regulatory conflicts, EU private international law foreign policy, and international harmonization. Next, we have Nikolina Marasovic. Is from Croatia. She graduated from the Faculty of Law at the University of Split. Her primary areas of research are constitutional law and the European Union law. Weronika Pietras is from Poland. She graduated at the Faculty of Law of the University of Rzeszów. Her research interests focus on constitutional law and the parliamentary law, which is reflected in the topic of her doctoral thesis. Lea Feuerbach is from Croatia. She graduated from the Faculty of Law, University of Zagreb. Her research focused on the criminological analysis of recidivism, specifically emphasizing of etiology, phenomenology, and potential prevention of reoffending. So, ladies and gentlemen, we begin in the first part, excuse me. This concludes the introduction of the Central European team. Now let us turn our attention to opposing team, the Polish team, whose members are ready to engage in today's debate. Leading the Polish team, I'm pleased to introduce the head of the team, Professor Marcin Wielec. Professor serves as a Vice Dean of Student Affairs at the head of the Department of Criminal Procedure at the Faculty and Administration at the Kardynal Stefan Wyszyński University in Warsaw. With the head of Polish team introduced, let us now meet the accomplished members of this team. So at first, Karol Rogala is a student of law and canon law at the Kardynal Stefan Wyszyński University in Warsaw, where he serves as a student's ombudsman. He interests Spain constitutional law, electoral law, administrative law, and local government law, a field closely tied to his role as a counselor in the municipal government. Next, Faustyna Zabielska is a fourth-year law student at the Faculty of Law and Administration at Kardynal Stefan Wyszyński University in Warsaw. She is the vice-president of the Medical and Pharmaceutical Law Scientific Association, contributing to research and projects in medical law. Her academic focus includes medical law and the protection of children's rights. Łukasz Sitkowski is a PhD student at the doctoral school of Kardynal Stefan Wyszyński University in Warsaw. Active in the doctoral students' self-government, he serves as the chairman of the board and a member of its parliament. His research interests encompass human rights, protection, constitutional law, religious law, criminal law, and international law. And Wiktoria Zwolińska is a student at the Faculty of Law at the Administration at Kardynal Stefan Wyszyński in Warsaw. She actively engaged in academic life, serving as a member of Student Government Board and as university parliamentarian. Her main areas of interest include children's rights, the protection of human rights, and the criminal justice system. So this completes the introduction of our teams. So, ladies and gentlemen, we now begin the first part of today's debate. focusing on the topic of the adoption of unified regulation as a response to current global challenges. Each team will present their arguments, supported by research, expertise, and critical analysis. To start, I kindly ask for your attention as I introduce the first speaker from the Polish team, who will present the elaborate on the opening perspective, introduction to the history of EU regulatory integration. Please, the floor is yours.
Thank you, Julia. So, the regulatory integration of the European Union reflects the evolution of cooperation between member states. At the beginning, it focused on the economy and the creation of a single market based on common regulations, eliminate legal and administrative problems, and promoting peace and solidarity. The first step in this direction took place when Europe was trying to rebuild after the devastation of the Second World War. The European Coal and Steel Community aimed at the joint management of key strategic stocks, coal and steel, which not only avoided rivalries between countries, but also reinforced the economic and political integration. The next step was the Treaty of Rome, which established the European Economic Community and Euratom. The EEC introduced a framework for cooperation in areas such as trade, agriculture, or transport, which indicated a process of legal harmonization in these areas. Today, the European Union is adapting regulation to challenges such as digitalization, climate challenge, of energy security. This process needs a balance between harmonization and respect for the diversity of member states, making dialogue and compromise crucial for the future of integration. Thank you so much.
Thank you for your valuable presentation. We now invite the Central European team to address the same topic and to share their perspective.
Thank you very much, Rita. So today I will provide a brief overview of the history of regulatory integration in the European Union. So the story begins after World War II with the Treaty of Paris, which established the European Coal and Steel Community. And this was Europe's first experiment with a supranational regulation, as it placed coal and steel production under the single regulatory framework. And this idea of joint regulation extended with the Treaty of Rome, which created the European Economic Community. And the goal here was to establish a custom union as ensured the free movement of goods, service, capital, and labor. However, by the 1980s, it became clear that the fragmentation regulations across member states still limited economic growth. So to address this, the Single European Act introduced the concept of mutual recognition, meaning production legally sold in the member states could be sold in all. This move paved the way for the creation of the single market in 1992, which required deeper alignment of rules on production, safety, competition, and labor standards. A major leap came with the Maastricht Treaty, which transformed the European Economic Community into the European Union and laid the groundwork for the Economic and Monetary Union. So this treaty expanded regulatory integration beyond trade, introducing rules on fiscal policy, justice, home affairs, and environmental protection. The introduction of the euro required strict fiscal rules to ensure stability. As the EU grew, new treaties like Amsterdam, Lisbon, and further strengthened the EU's ability to regulate areas like climate change, cybersecurity, and public health. This capacity became crucial during the 2008 with the financial crisis, when the EU established regulatory bodies like European Banking Authority. Today, regulatory integration extended to vital issues like climate change, with the European Green Deal settings a goal for carbon neutrality by 2050, and though common carbon pricing, emissions caps, and environmental standards, the EU is leading global climate efforts. Thank you.
Thank you so much, and we will now proceed with the second speakers from each team who will address the next aspect of our topic, adoption of unified standards in response of the current global challenges with a focus on administrative law. Ladies and gentlemen, please join me in welcoming the second speaker from the Polish team who will present their insights of this important focus area.
Thank you. Creating unified legal standards in the European Union helps member states tackle global challenges like climate change, digitalization, migration crisis, and protecting citizens' rights. Administrative law plays a key role in this process as it governs how public institutions work. Some examples of this effort include directives regulating public procurement procedures, which promote transparency and fair competition. Digitalizing public administration through the European Digital Strategy, setting standards for e-government services. In migration issues, the EU has established a common standard for processing asylum applications and cooperation between member states. The COVID-19 pandemic highlighted the need for unified administrative procedures in public health, such as the creation of the EU COVID certificate. To address climate change, the EU's Green Deal requires member states' administration to implement regulation for sustainable economy and energy policies. So, in my opinion, the EU should continue unifying standards only in areas where national efforts are not enough to address global challenges effectively.
Thank you so much. So now let us hear from the Central European team as their second speaker provides with the perspective at the same focus area.
Thank you, Julia. Ladies and gentlemen, administrative law plays an important role in effective governance and international cooperation. Harmonization in administrative law is particularly needed in areas such as the environment, where consistent rules on emission or environmental impact assessments are essential in the fight against climate change. In the area of public health, unified standards are essential for more effective management of crises, such as during pandemics, facilitating the coordination of activities such as quarantines or vaccine distribution. In the digital world, on the other hand, harmonized regulation on data protection, cybersecurity, or artificial intelligence enable fair and secure administrative decision-making. Technology, including common digital platforms and systems based on artificial intelligence, can significantly facilitate the implementation of harmonized standards, enabling real-time monitoring and enforcement. Key harmonization mechanisms are international agreements such as the Paris Agreement, which legally oblige parties to combat climate change, and supranational institutions such as the European Union and soft law instruments such as United Nations or Organization for Economic Cooperation and Development directives. The diversity of legal system, aspects of sovereignty, and the difficulty of enforcing standards remain a challenge. Harmonization of laws threatens sovereignty because it often requires states to give up a certain degree of legislative autonomy in order to conform to an international or supranational framework, potentially creating tensions between maintaining national control and achieving global or regional coherence. Thank you.
Thank you so much. So we will now proceed with the third speakers from each team who will address the civil law perspective on our topic, so adoption of unified standards in response to current global challenges with a focus on civil law. First, I invite the Polish team to present their perspective. Polish team, please, the floor is yours.
Thank you very much. One of the fundamental pillars of the European Union is the common market in goods and services. The removal of levies, duties, and other burdens arising from national legislation has required the European community to adopt common standards and procedures in the field of civil law. One of the most pressing topics has become the issue of liability for damage caused by defect in goods. Harmonization in this area manifested itself through the introduction of Directive 85/374 into law. This liability was to be borne by the manufacturer of the product or whoever present himself as the manufacturer, the producer of the raw material or of the parts, the importer into the Union, and, in the alternative, the supplier of the product. In some simplification, it can be said that a manufacturer is liable if he has placed the product on the market. The defect already existed at the point in time, and the product was manufactured or distributed by him for a commercial purpose or in the course of his business. A new breakthrough area is AI liability. The Council is working on directive known by its working title, the Artificial Intelligence Liability Directive. The AI Liability Directive aims to make it easier to assert one's right in court. The piece of legislation aims to equip national courts with the power to oblige a defendant, at the request of a plaintiff, to order the disclosure of evidence relating to a particular artificial intelligence system alleged to have caused harm. The condition for exercising the power is that the plaintiff has first made such a request to the person subject to the provider or user's obligation and received a negative response. The final form of the directive is still awaited. Thank you.
Thank you so much. And now next we turn to the Central European team as their third speaker present their perspective on the same focus area.
Dziękuję. The successful operation of the internal market is assured when standards set by the fundamental freedoms are upheld in the process of application of EU law and especially member states' domestic rules. That being said, the CGU constitutional competence, embodied in the preliminary rulings procedure, serves as one of the foundations of the autonomy of EU legal order and a prerequisite for refereeing between different national standards. As already had in Internationale Handelsgesellschaft case and reaffirmed in Meloni case, the binding effect of CGU rulings aim to avoid a situation in which the level of protection of fundamental rights varies according to the national law involved in a way that undermines unity, primacy, and effectiveness of EU law. It proceeds that the standards of protection in EU can only be properly assessed through the scope of freedoms associated with the proper functioning of the internal market. If justified by imperative reasons of general interest of the forum, restrictions on the free movement must be applied in a non-discriminatory manner, complying with the principle of proportionality and be compatible with the observance of human rights. Based on the systematic interpretation of the primary law and taking into account the principle of coherence of the internal market, which says that every EU law rule must be put into its context and interpreted in the light of the ever-evolving EU law as a whole, the principle of equality as codified in the Article 6, read in the light of Article 2 of the TEU, has both vertical and horizontal effect and behaves as a habilitating rule which assesses the compatibility of the national rules and measures with the treaties, Charter of Fundamental Rights and European Convention on Human Rights. Due to presence of concurrent jurisdictions, legal certainty may be jeopardized unless the application of substantive laws across the involved fora yields the same results, ensuring what has traditionally been referred to as decisional harmony. On the level of choice of law, the application of foreign law by domestic courts have been compared to jumping into the dark, since the law of any state may be selected according to the respective connecting factor, because it does not take account of the context of the selected substantive rules. In the context of judicial cooperation between member states, this normative solution can only be successfully employed if the participating parties trust in each other's substantive laws, but at the same time the design of neutral connecting factors is only feasible if the legal systems of all involved states are regarded as equivalent in delivering justice. Thank you.
Thank you so much. And now we move to the final speakers for this topic, who will address the criminal law perspective, adoption of unified standards in response to current global challenges, with a focus on criminal law. First, the floor is yours, Polish team.
Thank you, Julia. In the face of global changes such as transnational organized crime, the need for harmonized standards agreement is emerging. For Poland, which is included in the European Union, it's becoming a priority to apply laws to general standards, particularly with regard to combating corruption, cybercrime, and fighting organized crime. Examples of this are available in the Polish Criminal Code, the Polish Code of the Criminal Procedure, and cooperation during executive of the European Arrest Warrant, which enable the implementation of the principles. However, the final consistency with the conclude guidance are corollary of the action that include basic principles of the Polish legal system, such as protection of the individual rights and the principle of proportionality when imposing penalties. Thank you.
Thank you so much. So lastly, I invite the Central European team's final speaker for this topic.
Thank you, Julia. Ladies and gentlemen, the adoption of unified standards in criminal law within ever integrated in Europe is a necessary response to the pressing challenges posed by organized crime, human trafficking, and cybercrime. This issue transcends national boundaries, exploitive gaps in jurisdiction and enforcement, and demand a coordinated legal framework to ensure justice and security across the European Union. Unified standards are vital in promoting equality and the principle of legal certainty, ensuring that similar offenses are treated consistently across all member states. For example, European arrest warrant demonstrates how harmonized frameworks facilitate effective cross-border cooperation. However, unifying criminal law standards is not without its challenges. The legal system of member states are deeply rooted in their historical and cultural traditions, with significant difference in procedural safeguards, evidentiary rules, and sentencing practice. For example, while some states adopt a rehabilitative approach to criminal justice, others emphasize deterrence and retribution. Balancing harmonization with the principle of subsidiarity enshrined in Article 5 of Treaty on European Union is therefore a complex task. To overcome these challenges, European Union must focus on enhancing the mutual recognition of judicial decision, a principle established by Temporary European Council in 1999. Unified standards also play a crucial role in safeguarding fundamental rights as guaranteed by Charter of Fundamental Rights of the European Union. In conclusion, the adoption of unified criminal law standards is more than a technical legal development. It is an expression of shared values, a commitment to equality, justice, and security. By bringing legal disparities while respecting diversity, the European Union can address global challenges effectively and build a fairer and more cohesive legal order. Thank you.
Thank you so much. And concluding the presentation on this topic, now I would like to invite the teams to engage directly in the discussion. I encourage members from each team to take this opportunity to ask questions for their counterparts on the opposing team. So please, the floor is yours.
Okay, so I have one question, very important, I think. So, in your opinion, what are the greatest risks associated with the current trend toward unified legal standards within the European Union? Thank you.
So we can say the divergent and different interpretation application of the uniform EU law at the level of national courts undermines legal certainty and predictability of the outcome of the litigation and is strictly contrary to the achievement of the objectives of Article 4.3 of the EU. However, one cannot ignore that in practice the national legal systems and actors behaved and often continue to behave in ways which were and remain not strictly in line with the requirements of EU law. EU law is not always applied correctly by national authorities and courts. In particular, the obligation for national courts of last resort to refer issues of EU law to CJEU for preliminary ruling procedures were not respected constantly in the practice. So we can say that the biggest problems associated with this is the risk of applying EU law purely within the national context and reaching decisions which cannot be accepted abroad the EU.
So, any other questions?
We also have one question. In your opinion, do you think that the existing regulatory models in Poland are effective enough in dealing with the current challenges? in recent time, or would harmonizing with European standards bring significant advantages?
Thank you for the questions. The current regulatory models in the Polish legal system are fragmented into many configurations, can be tools for the future in combating problems common the European Union, such as cybercrime and migration. Harmonization of the national law, respective in the principles of the national legal order with the European standards, can important significant benefits, including coordination of activities, consistency of the rules, and particular advice in addressing problems for application. Thank you for attention.
So thank you so much. And now before we move to the next segment of today's debate, I would like to thank both teams for their presentations and engaging discussion during this first part. And now we will take a 20 minutes coffee break. So let's enjoy the coffee break. Thank you so much for this part.
Bardzo ładnie. No, Ofra, thank you very much. Oh yeah.
Przepraszam cię, czy... Gdzie to jest toaleta? Chodźcie za mną.
Toaleta na dole.
Weteran, jak chcesz wiedzieć. Weteranem w ogóle, bo to pierwsza...
Nie, wiem, że to była pierwsza edycja.
Tak, ale to było jeszcze, słuchaj, chyba online. Online to było online. To do 11.
Jak odpowiadał, to bym to jakiś kontekst znaleźć. Specjalnie się patrzę,
Tak.
ja myślałem, że to nie się zepną. Ale oni to tylko... Nawet gorzej niż 400. No.
Fajnie, kurde, jak się też kurczę na tym...
Tutaj. Mogłem przedłużyć tą odpowiedź względem reakcji.
Nie, no wiesz, nie jest dla ciebie, dla mnie to znowu zabawne. Śmiało i z perspektywy czasu minie ci to, naprawdę ci to minie. No to jest po prostu zawsze.
No właśnie widziałem, ja z nim byłem na akademii. No,
A, właśnie, no ale dobra, to w razie co, bo i tak nie było za mało miejsc. 2015, Paweł sobie przyjechał i tak, ale muszę. Nie no, nie, miał się
cześć. Smooth.
Zaraz 10 punktów, jeszcze wcześniej skończymy.
No dokładnie. Bardzo dobrze.
Ja bym się, ale fajne są okoliczności tego. Fajnie to wygląda, jak tak uniwersytecko jest.
Tak. Zupełnie inaczej.
Dzień dobry.
Powiedzmy swoje nazwiska.
Łukasz
Potrzebuję
Szykowski.
potrzebuję wpisać na media społecznościowe.
Nie ma problemu.
Nie ma problemu. Łukasz
Karol to wiem, pan Karol Rogala.
Tak jest.
Pan Łukasz.
Sitkowski.
A pani?
Faustyna Zabielska
Teraz wiesz, weszli studenta od 1 stycznia.
i Wiktoria Zwodnicka.
Wydał w końcu czekarski, więc jesteś trochę na czekaniu.
No wiem, ale już jest. Ale prawomocne od 1 stycznia, nie?
1
Wchodzi
stycznia,
w
bo
życie.
tam mamy wprowadzenie stanu kalendarzowego. Żeby nie było wątpliwości, że nie muszę od rana wywoływać.
Ładnie. Będą mieli rzecznika. Ona jest
ale ona wie, malowała panoramę. Ona i nagrała materiały na Instagrama. Jest więcej na Facebooku. No, Justyna jest. No, dokładnie.
Jak tam?
Poza tym
Gratuluję objęcia funkcji szefa.
Szefa
Wybrali.
wszystkich szefów.
Wybrali do
Gratuluję udzielania się na kanwie samorządowej. Śledzę na Facebooku czasem film.
Dobrze, dziękuję.
pieniądze
A zresztą
pozyskane.
przecież...
No ja też.
Wszystko samorządowo.
Tak.
Brać.
No ale tak, jak kasy macie, no to zaraz to, że niech to drogę wkładą tylko, nie?
No tak, to prawda.
No nie, no ale...
Fajnie.
Ale myślimy na wszelki wypadek.
Ja mam Krzysztof, ale nikt nie chciał, nie? Ja się ja promowałem tam jak mogłem, ale nikt nie ten. Ale też wiesz, ja byłem taki dodany do ostatniej chwili, bo dla mnie był Bartek, tu chcemy dopiero tam. No i mam 30 osób. Jeszcze jeden akurat przychodzi do mnie tak, no. No i miało jeszcze się jeden chyba dopisać, nie? Ale no, nie wiem. Myślę, że to nie jest taka, bo 18, no ale wiesz, może na przyszłym semestrze będzie więcej. Żeby jak to, na przykład, bo do mnie ktoś mają pewnie tego samego dnia wszystkie zajęcia, nie?
No tak, ja na przykład w drugim semestrze miałem 3 grupy już z tego
Tak?
programu.
No, a to kto jeszcze jeden z tym?
Może ty, albo Bartek. Nie, Bartek może, co?
Nie wiem, no, bo ja to tak, znaczy chyba, że na... No i tak, no to jak dostanę 2, no to może ktoś przyjdzie. W ogóle za dużo jest jednak, bo tak naprawdę.
Ja na przykład, ja znacznie wolałem, jak mieliśmy takie grupy po 16 czy po 17
No było 25, bo...
Jak mam, a jak jeden mam 27,
No, nie, no to w ogóle tak, ale wiesz, ja mam 6 osób, to w ogóle o wiele lepiej jest, nie?
to jest jak
Takie
się
konwersatorium, no. Wiesz,
Jeszcze można pizzę zamówić, sobie Coca-Colę wziąć.
z każdym wiem kogo mam w grupie, w ogóle wszystkich znam, bez problemu. No, także...
A tak, to jest też, ja raz tam właśnie wbiłem na ćwiczenie, to taka atmosfera, tak.
Co, 6 osób, tak?
Dzisiaj jeszcze nie mam ćwiczeń, bo przebyłem jak to...
Tak, godziny są od 18.
Tak,
A ty masz 18:30? No to...
Ja na przykład widzę po sobie, że jak bo miałem takie mniejsze grupy, takie do 20 osób, byłem w stanie nauczyć się wszystkich.
Ale ja pamiętam, jak miałem z tobą zajęcie nawet.
Tak,
no
ja teraz jak uczę
teraz masz przecież
100 osób,
100 osób, no to nie ma szans.
to do mnie ktoś mówi dzień dobry, a ja się czuję właśnie jak ktoś...
No kiedyś były 2 grupy, znało się każdego z nazwiska.
Tak. Ja na przykład wszystkim pamiętam.
No.
Maciej Barwosz, Katarzyna
Jest,
Dobrzyńska.
Maciek Barwosz jest doktorantem, drugi rok.
Tak, ja go raz spotkałem, tak.
Ma też grupę na administracji, prowadzi teraz. Ojej, na prawie, ale administracyjną.
Tak, administracyjny,
Tak, na prawie ma jedną grupę na drugim roku, tak. Dzisiaj ma zajęcia, tam chyba o 15.
Mam propozycję. Skoro jesteśmy, tak, nie, tak jak ojciec wcześniej. Skoro jesteśmy już na wspólnej kanwie naukowej jako koledzy, musimy sobie po imieniu.
Dobrze, dobrze.
Marcin.
Dobrze. Karol.
Marcin.
Wielka przyjemność.
Wielka przyjemność, dokładnie.
Jesteśmy już kolegami na kanwie, więc ja sobie już podam.
A, bo to jest
Tak, tak. Uważam, że na tym polega właśnie dobra współpraca, abyśmy sobie już nie panowali.
Dobrze. Może być, chyba słychać.
Tym bardziej, że Tomek jest chyba rok starszy Od was.
No ode mnie jest rok, 2 lata
Tomek
starszy.
jest 9,7, Łukasz jest 9,5,
9.
ja jestem 0,0.
No właśnie.
No, 2 lata starszy jest
No
ode mnie.
jesteśmy jakby jeden wszędzie.
Ale Natalia Wituła na przykład, czyli Dzięcielska jest 9,8.
A, no tak, to
No,
się wszystko
to jest.
łączy.
Ja
to.
na przykład też sobie zdałem sprawę, że do Tomka powiem po imieniu, tutaj panujemy sobie, ale różnica z jednego roku.
No tak, można tak powiedzieć.
Chociaż na przykład jak ja spotkałem się z, jak się ten gość nazywa? Marcin od KPC. Marcin
Białecki.
On jest ode mnie źle starszy, ale
No on jest.
on zupełnie
Nie widać
po nim. Ja do niego
Ale
zacząłem mówić
jest.
na ty, a ja potem zobaczyłem Festival,
Ale
on
myślę,
jest,
że
tak,
on by się nie obraził.
Tak, to jest inny mindset. Chociaż tak samo Ola Syryk chyba, tak? Ona do mnie mówi na ty, ja do niej mówię na ty, a potem zobaczyłem, że ta różnica wieku jest trochę większa. Ale to ogólnie na luzie.
No jak?
Chociaż ja, na przykład dużo jest ludzi, których ja do tej pory nie poznałem, tak? Mimo, że mam te czynności administracyjne, które z szefem czasem robimy i ktoś do nas maile pisze, jakieś komisje sprawozdawcze. Dużo jest ludzi, którzy sobie panujemy, bo nawet się nie wrzuci na oczy nie chcieliśmy na UKS-u, bo oni są jakieś, niektórych na przykład nigdy nie mijamy.
Niektórzy też tam prowadzą tylko na nie stację, mają ćwiczenia, jest multum takich osób,
Tak.
mają tylko
I
umowy
nie widzimy
cywilnoprawne.
właśnie, nie widzimy ich na co dzień, w sensie no...
I później Wiktoria do mnie coś tam, że kto to jest, czy polecam, ja mówię, Boże kochany, nie znam człowieka, nie?
No to doktoranci zazwyczaj tych
No
z
tak, albo
wolnej
jacyś
stopy.
doktorzy, tak
No.
właśnie, którzy gdzieś
No.
tam sobie dorabiają jeszcze
No.
weekendami. Nie?
Albo tak.
O, już tutaj
Nagrody?
Nagrody na drugą część.
A jak się będą podoba? Macie jakąś
Mamy,
interwencję większą?
nie, to tak
Właśnie przy tym wyjeździe
większej.
nie, ale mieliśmy w Budapeszcie,
W
we
Budapeszcie.
wrześniu.
To wtedy
To
tak,
tam
to
faktycznie
wtedy
fajnie.
faktycznie
Ja byłem
można było się
w zeszłym
zapoznać
roku, właśnie
bardziej.
w zeszłym roku byłem na tych dwóch konferencjach Unii i organizacja tam była top, tak, że każdego...
To nie
to jest inny świat w ogóle.
To
My
jest
jeszcze słuchaj, tak trafiliśmy, że była
Przyjeżdża
akurat
się-
powódź w Budapeszcie, więc nie było tej słynnej kolacji na statku. Nie płynęliśmy, ale siedzieliśmy nad Dunajem normalnie na
Tak, ale to jest tak, to tak jakbyśmy, nie wiem, w Warszawie zapraszali do Krasy,
Dokładnie,
na jakąś kolację
nie?
degustacyjną, dwa najlepszych jakichś miejscach,
No,
jakby w szoku.
Kasa jest na to
Tak,
potężna.
że na przykład były 3-daniowa kolacja i do każdego można sobie było inny alkohol wziąć, tak? Że piwo do przystawki, wino do
Tak, bo oni też
tego i
właśnie
coś jeszcze na
serwują
deser.
normalnie piwo, nie? Dla mnie to nie było takiego dużego.
Ale na przykład nie wiem, czy wiecie,
No wszystko
że
można.
w Niemczech, jakbyście pojechali na jakąkolwiek kantynę uniwersytecką, to w stołówce można piwo sobie zamówić do obiadu, tak?
To normalne, to pewnie norma tam.
No to jest jedno piwo, no powiedzmy
Co to jest
sobie
jedno
szczerze,
piwo?
tak?
No,
Ja staram się mimo to nigdy nie prowadzić.
Nie, no tak,
bo
nie,
trochę
to absolutnie. ale-
Raz wracałem po weselu następnego dnia, ale nadal czułem, że nie jestem w pełni
do
świeży.
końca.
Tak? Mimo, że przespałem się, mimo, że dzień minął, to jak wieczorem miałem jechać autem, to czułem się, że ja gdyby
Że
zatrzymał
dalej
policja
coś tam-
pewnie to
coś tam
by
jeszcze mogło
było.
być.
Mimo, że wiesz, że moja waga jest znacznie większa niż abym ważył, nie wiem, 60 kg na przykład, i wypił tyle samo. Ale to jest właśnie ta... A jak to było przecież na studiach, jak się nieświeżym sam jechało na zajęcia.
Mi się akurat mówiąc szczerze chyba nie zdarzyło.
Nie było połowinek?
Nie.
Nie, bo pandemia była, tak?
No i
To też, ale nie było takiej tradycji w ogóle tutaj.
Nie, to teraz dopiero
To teraz
ten
były
rocznik
pierwsze.
po tobie. To był chyba pierwszy, tak? Bo dobrze liczę, czy jeszcze następny?
Nie.
Jeszcze
Dwa
następny.
roczniki.
O tak, jeszcze
0,2.
następny.
0,2 miało połowinki. Teraz wiem, że 0,3 też ma połowinki, bo tam Ciekaw Więckowski określił mi opowiedź.
A jak wasz rocznik ogólnie? Wszyscy skończyli z sukcesem?
Wydaje mi się, że tak, bo tam, znaczy powiem tak, my byliśmy takim ostatnim rocznikiem, gdzie nas przyjęto 180 osób na studia. No już
A ile
kolejne.
skończyło?
Następne są po 300. Więc tam samo przejście jest trochę inna już robota. Ja na przykład znałem cały swój rocznik. Gdzieś tam później jeszcze działałem w
na
samorządzie.
planie stacjonarnym roczniki są po 60 osób. I
Ale teraz przyjęli potężny rocznik. Praktycznie limit wypełnili.
No zobaczymy,
To się nie zdarzyło.
Tutaj ja też mam wątpliwości, co klasyczne powinny być na pierwszym roku, bo dużo ludzi odpada nie dlatego, że sobie nie daje rady, tylko dlatego, że się nudzi.
O, ksiądz profesor Posek.
No.
Fajnie. A może mieć też jakiś wykład czy coś. Tak? Albo rodzinne ćwiczenie.
Wbrew pozorom nie jest tak mało osób na tej widowni. Jestem zdziwiony.
Ogólna uniwersytecka.
Na wydziału.
Na wydziałowej, tak, na wydziałowej.
A kiedyś to było?
W tym roku, że tak powiem.
Na przykład nawet na wigiliach pracownicy. Co będzie? Będziecie na nie?
Ja mam Radę Dyscypliny, na której jest zatwierdzany mój indywidualny plan badawczy, więc ja siłą rzeczy muszę być na Radzie Dyscypliny.
Ja to jestem na chociaż jak coś poproszą mnie o pomoc, to nie ma żadnego problemu.
Jeżeli zaproszą doktoratów, którzy będą, to pójdę.
Ale to mnie nikt nie zaprasza. Się chciałem samemu dowiedzieć, kiedy
kiedy
wigilia
jest
pracownicza.
To...
Gadaliście z swoją Olą i ona mówi, no jeszcze jedna zesłała mail, ale jest, tak? A trochę tak na wariacji
O 15 bodajże.
Tak, a trochę tak powinniśmy wcześniej o tym wiedzieć, a nie tydzień przed.
To prawda. Znaczy ja się wybieram na uniwersytecką, na Dewajtis w Łomszowie.
No tak, za tyle.
Życzenia świąteczne składam.
Życzenia świąteczne składam. Też mam zamiar się pojawić. Mam tego samego dnia o 14 jest opłatek uniwersytecki, a ja o 18 mam opłatek w gminie.
No, a ja mam o 18 samorząd doktorantów.
Czy
Jak wygląda praca w gminie?
Fajnie. Mnie się bardzo podobał. Czasami
No bo to jest mała gmina, tak?
11 tysięcy mieszkań.
To można...
Ale na komisjach siedzimy po 4-5 godzin. Czasami jest naprawdę dużo.
Mam pytanie odnośnie dofinansowania gminy. To naprawdę w takich małych gminach łatwo to zdobyć?
My akurat jesteśmy, że jesteśmy w tym okręgu warszawskim i dla nas środki unijne to jest katorka, ponieważ musimy mieć 50% wpłaty. Teraz strój,
no tak, gmina mieliśmy to główny dochód, to są podatki od mieszkańców, tak?
Podatek od nieruchomości jest głównym udziałem.
A mniej ludzi mieszka?
Oprócz oczywiście subwencji. Teraz kiedyś było tak, że była subwencja oświatowa, jakaś tam taka była subwencja ogólna. Teraz rząd zmienił politykę, jest wtedy jedna subwencja. Po prostu zrobili tak, że zmienili przepisy dotyczące PIT-u. Z PIT-u będziemy stawiać jakieś więcej niż wystawaliśmy, ale wychodzi praktycznie na to samo. Różnica jest w przewieszeniu. Tak jak my mamy budżet, wydatki, to jest milion. Na przyszły rok. Tak.
Ale generalnie to właśnie widać, jak państwo działa od wewnątrz, pod drzewki. To jest na pewno bardzo fajne, bo macie na to wpływ. Z drugiej strony to jest trochę denerwujące, więc myślę, że macie na to wpływ, ale de facto nie ma byście w tych ramach.
I my też jesteśmy jakby zmuszeni tym, że na przyszły rok na oświatę mamy zaplanowane wydatki 40 milionów, gdzie z państwa dostaniemy, jakby tak licząc, troszkę więcej niż połowę, 20 parę milionów, a kilkanaście trzeba dołożyć. W tym roku dołożyliśmy 12 milionów do oświaty. Płaca minimalna rośnie, nic nie wiadomo. Teraz rząd faktycznie zapowiedział, obiecał zrobić tak zwaną kroplówkę na koniec roku. 2 miliony złotych. Ale to jest nic, to jest kroplowa. A koszty rosną koniecznie. Energii.
No, generalnie władze centralne chciałyby, aby gminy same na siebie zarabiały, ale nie każda
To jest dokładnie tak. To jest niemożliwe praktycznie, dlatego my też łapiemy jakąś każdą inwestycję. Teraz właśnie sprawiliśmy, że gazociąg, który będzie przechodził przez naszą gminę, będzie jakaś stacja kontrolna, gdzie co roku tak naprawdę od wartości tej stacji będzie wpływał podatek. To będzie rocznie 200-300 tysięcy złotych, to zawsze co? Więc nawet o takie małe rzeczy trzeba gdzieś tam walczyć, żeby faktycznie te o środki, dużo mamy na przyszły rok środków wewnętrznych, bo jeszcze to jest pokłosie do 23, więc mamy środki, więc są,
jest wyłączone, nie? Tak, czy nie?
And we have a lunch and really good. Yes, my spy gave me information.
And you know, she started to learn Hungarian, Croatian, and she's in the tribunal.
Yes, but maybe it's not my seminary and the parallel in substantive law. But I checked.
Okay. Because she was really
nice.
open and
Yeah. Maybe next our doctoral student.
who knows, we are ready.
Yeah. Okay. No. So let's get ready.
Ja jestem pierwszy.
So, ladies and gentlemen, welcome back from the break, and I hope everyone is refreshed and ready to continue with the second part of today's debates. So, the discussions so far have been engaging and insightful, and I am confident that this is the next segment will be just a thought-provoking. So, we will now shift our focus on the second main topic of today's debate, equality as a foundation for cooperation between EU member states and the EU. The discussion will begin with the Central European team, who will present their perspective on the equality in EU treaties and case law from European courts. Central European team, the floor is yours.
Thank you very much. So equality was first introduced in the Treaty of Rome, which the concept of equal pay for equal work for men and women. Over time, this principle expanded, and the Treaty of Maastricht introduced EU citizenship, giving all EU citizens equal rights to live, work, and access social benefits in any member state. The Treaty of Amsterdam took a major step forward by broadening anti-discrimination laws to cover race, gender, religion, disability, age, and sexual orientation. So the most significant changes came with the Treaty of Lisbon, which made equality a core EU value under Article 2 of Treaty of European Union, and it also gave binding force to the EU Charter of Fundamental Rights, ensuring protection against discrimination on all key grounds and reinforcing the concept of equal treatment for both citizens and member states. The European Court of Justice has played a crucial role in applying these principles, so key rulings have strengthened rights for individuals. In the Freyne versus Sabena from 1976, the court confirmed that the right of equal pay for men and women could be enforced directly by individuals in national courts. In the case of Grzelczak from 2001, the European Court of Justice ruled that the EU citizens must receive equal access to social welfare benefits when living in another EU country. Other landmark cases include Firma Feiern, where the court ruled that public statements of discriminatory hiring practices violate anti-discrimination law, even without specific victims. In the other case, Coman versus Romania, from 2080, the court ruled the same-sex marriages must be recognized across the EU residence purposes, even if the member states does not recognize same-sex marriage. Equality also extended to member states, and the EU ensures that large and small countries have a fair say in decision-making, notably through the qualified majority voting, and the EU strives to ensure that all countries, regardless of the size, are treated with the respect and fairness in the EU institutions. Thank you very much.
So thank you so much for your detailed presentation. Now we turn to the Polish team, who will share their perspective on the same topic. Polish team, the floor is yours.
Thank you. The principle of equality with fundamental pillar of the European Union law is not only enshrined in European Union rights, such as right on the functioning on the European Union, but also development in the case law of the Court of the Justice of the European Union. In the context of Polish law, the principle has been implemented inter alia in the Article 32 Constitution of Republic of Poland, which answer equity before the law for and prohibits discrimination from accessibility at that. In national settings such as Labor Code of the Equal Treatment Act is employed for utilitarian purpose. For example, regarding gender equality residence. Polish courts, including the Supreme Court, are increasingly referring to the Court of the Justice of the European Union rulings, such as the Friend versus Sabena equal dignity case, to answer compliance with uniform. Not less, full implementation of the principles of the equality in the Poland requires such measures in which information on institutional monitoring discrimination available. Thank you very much.
Thank you so much. So next we turn to the Central European Team's second speaker, who will address the topic equality in the doctrine and jurisprudence of member states. So please, the floor is yours.
Thank you, Julia. So, ladies and gentlemen, the principle of equality is one of the cornerstones of democratic state under the rule of law, and its implementation reflects the degree of protection of human rights and social justice. Due to limited time, I would like to focus just on case concerning Poland. So, equality in Polish doctrine and jurisprudence is based on provision of the Polish constitution, as Łukasz mentioned, particularly Article 32, which guarantees equality before the law and prohibits discrimination on any grounds. Article 33 further emphasizes equality between men and women. Polish law also takes into account the Equal Treatment Act of 2010, which implements EU directives covered in the area of non-discrimination, as well as provisions in the labor and criminal codes that protect against discrimination. The Constitutional Tribunal plays a key role in interpreting the principle of equality, ruling cases related to gender equality, rights of persons with disabilities, or religious freedom. Polish courts also make use of achievements of EU law and the jurisprudence of European Court of Human Rights, particularly with regard to the protection of minority rights and anti-discrimination. One of the cases settled by the Constitutional Tribunal was a case involving a labor code provision protecting pregnant women from termination. The constitutional complaint raised that the accusation that this regulation may violate the principle of equality, but not providing similar protection for men or other groups of employees. The tribunal found that the legislation to be in compliance with the Constitution, arguing that the differential situation of pregnant women and other employees is justified by special biological and social circumstances. It pointed out that the protection does not violate equality, as it aims to compensate for the real inequalities affecting women during pregnancy and maternity. The judgment stressed that the principle of equality does not mean treating everyone equally, but taking into account the specific needs of different social groups. Thank you.
Thank you so much. So now we invite the Polish team's second speaker to share their perspective on the same topic.
Thank you very much, Julia. Equality in the Polish constitutional order is one of the most important principles on which social relations live, and the state-human relationship are based and provides the basis for the functioning of the centers of judicial power. Literally, it reads, all persons shall be equal before the law. All persons shall have the right to equal treatment by public authorities. No one shall be discriminated against in political, social, or economic life for any reason whatsoever. The principle of equality in the wording of Article 32 of the Constitution is a general principle. lex generalis. It is universal in relation to the other constitute norm in a basic law relating to concretized equality. In the jurisprudence of the Constitutional Court, it's one of the fundamental values of a democratic state under the rule of law. However, it cannot be said to be a mathematical equality, everyone equally. No, it's not an arbitrarily expressed norm. It's not a premise for unequal treatment of discrimination. The court pointed out in one of its judgments, the principle of equality is respect when every citizen can become an address of any of the norm granting a specific civil right. From the point of view of the principle of equality, it's therefore impermissible to differentiate between citizens on the basis of such criteria that lead to closed categories of citizens with a different legal status. The essence of this norm is the conclusion. The legislator is obliged to enact law in such a way that they do not contradict the principle of equality. Thank you.
Thank you so much for your thoughtful response. So we could now continue with the third speakers from each team, focusing on the equality in the context of cooperation in civil matters. Let us begin with the Central European teams, as their third speaker presents their perspective. Please, the floor is yours.
Thank you, Julia. So the menu of multi-state cases demonstrates that cross-border litigants share common demands: equal access to justice in an appropriate forum, legal certainty as to the law applicable to their transactions, ability to enforce fairly obtained judgments in other countries, and simple, efficient, and cost-effective mechanisms to make cross-border litigation work. To provide so, robust international framework on judicial cooperation in civil matters comprises rules on service of process, taking of evidence, and access to foreign law. International service of process is regulated by Hague 1965 Service Convention. Whenever the defendant cannot be served within the jurisdiction, the service of process abroad is needed. Notice to a defendant is required by procedural justice, and where a judgment is to be recognized or enforced in a state other than its state of origin, absence of notice may be a ground for refusal of recognition or enforcement, as under Article 7 of Hague Judgments Convention or Article 45 of Bristol 1bis regulation. These rules protect the defendant by ensuring the right to be heard in response to a document that contains the essential elements of the claim to which the defendant is to respond. If all these requirements are met, the transmission channels provided under the Convention must be applied. Based on Convention rules, EU service regulation prevails over Convention between member states, but it is still used for service of process in third states. International taking of evidence is governed by the Hague 1970 Evidence Convention that created cooperative procedures and reduced the obstacles of the latter's rogatory system which preceded it. Albeit the most matters of evidence are questions of procedure governed by the law of the forum, when the testimony of a person or documents in their possessions are located in a foreign state, comity and pragmatism require regard to be had to that law of that foreign state. In that regard, Article 9 provides for the application of the procedural laws of the place from which the evidence is sought, while certain procedural laws of the forum at the latter request may be accommodated. I argue that purposive interpretation of chapters 1 and 2 supports the mandatory character of Hague Evidence Convention when evidence within its scope is to be taken or obtained abroad, as convention aimed to reconcile conflicts of law between distinct approaches of civil and common law systems, while Article 23 permits contracting parties to deny execution of letters of request if the requested procedure is manifestly incompatible with the law of the requested state. Non-mandatory interpretation would go against this objective. And finally, access to foreign law is a condition for proper application of that law. At the EU level, Council Decision 2001/4070 set up a European Judicial Network for Civil and Commercial Matters as a system for access to foreign law. Maintained by contact points and liaison judges, it significantly improved communication between member states. In contrast, the official governmental site's primary objective is not providing a service to foreign operators. Much is still to be done to make legal information freely available to the legal professionals of a foreign origin. A first glimpse into a given foreign law can be achieved via information sheets such as those published on the EU Justice Portal. Although the duty to inform on their national law is imposed by the EU, the accuracy of information depends on each member state. Since non-compliance prompts no sanction, I contend that a kind of quality control of the information is due under the Articles 3 and 4 of the TEU. Thank you.
Thank you so much for your comprehensive presentation. So now, next we invite the Polish team's first speaker. Please, the floor is yours.
Thank you, Julia. Equality in the context of cooperation in civil matters refers to regulations that ensure uniform treatment of individuals regardless of their nationality. Cooperation in this area is crucial to maintaining consistency among the legal system of the EU member states, particularly in cross-border civil cases where individuals from different countries must operate under uniform standards. Civil cooperation within the EU is based on regulations that protect citizens' rights and ensure fair and transparent procedures. Examples of these regulations that uphold equality in civil matters include Regulation EU 20/1911. This document is a key element of legal cooperation among member states in family matters. It governs the recognition and enforcement of judicial decisions in marital cases. European Payment Order, a simplified judicial procedure enabling quick and effective recovery of monetary claims in cross-border cases without initiating lengthy court proceedings in individual member states. Rome I and Rome II regulations. These unify the rules on the choice of applicable law in civil and commercial disputes, and preventing one party from being privileged based on the jurisdiction where proceedings take place. Thanks to these regulations, parties involved in disputes are ensured equal conditions, regardless of which member states handle the case. Thank you.
Thank you so much for your detailed presentation. So to conclude this segment, we turn to our fourth speakers who will address the equality in the context of cooperation in criminal matters. So first, we invite the Central European team to begin.
Thank you, Julia. Ladies and gentlemen, equality is the cornerstone of cooperation of criminal matters between EU member states and the European Union. This principle underpins the European Union's commitment to fairness, mutual respect, and the protection of fundamental rights with a diverse legal landscape. In criminal matters, equality ensures individuals, regardless of their nationality or the member state in which they reside, are afforded the same protection under the law, and the cooperation between the states is based on mutual trust. One of the most notable manifestations of equality in this context is the principle of mutual recognition, which serves as the foundation of European Union judicial cooperation in criminal matters. Established by Temporary European Council in 1919, mutual recognition aims to ensure that decisions made by judicial authorities in one member state are respected and executed in another. European arrest warrant exemplifies this principle, enabling the swift extradition of individuals across borders while ensuring procedural safeguards are upheld. However, achieving this equality in the main is not without its challenges. European Union comprises member states with diverse legal tradition, procedural rules, and standards for fundamental rights. For instance, difference in the application for fair trials rights as guaranteed by Article 47 to 48 of the Charter of Fundamental Rights of European Union can create disparities in the treatment of individuals. Ensuring equality requires harmonizing these procedural standards while respecting the principle of subsidiarity outlined in Article 5 of the Treaty of European Union. In conclusion, equality in the context of cooperation in criminal matters is essential to ensuring justice and fairness within the European Union. It fosters mutual trust, protects individual rights, and facilitates effective cross-border collaboration. By upholding shared values and harmonizing key aspects of criminal law, the European Union can overcome its legal diversity while respecting the sovereignty of its member states. Equality is not merely a principle, it's a foundation for a fair and just European legal order. Thank you.
Thank you so much for your detailed contribution. So with this, we have concluded the formal presentations on our second main topics. So I would like to open the floor for a dynamic exchange of the question between the teams. So teams, the floor is now open for your questions.
Julia.
Yes. Sorry. Oh my God. So please, Polish team, the floor is yours.
Thank you so much, Julia. Equality is a key principle of cooperation in criminal matters in the European Union, in freedom, security, and justice. It means that European Union citizens, regardless of their country, are treated equally and have the same access to justice. The European arrest warrant in an example of the application on the principle of equality in practice. It is a key tool of judicial cooperation in criminal matters in the European Union. It is main objective in the swift and effective transfer of person suspected or convicted in one member state to another when they are to be tried or serve their sentence. Equality is also found in the European Investigation Order, which enable criminal investigative activities to be carried out across the Union. This tool ensures a uniform standard of evidence collection, regardless of which country it is obtained in, and it is way. All parties to the proceedings, defendants, witnesses, as well as victims, are guaranteed equal treatment and respect for their rights. So these tools are based on the participate of mutual recognition of judicial decisions between member states. Equality, equality in this cooperation gives trust and ensures that every union citizen has the same right and obligation, regardless of borders. So thank you so much.
So now it's time for questions. Excuse me, Victoria, once again. So now it's time for question. Team, the floor is yours.
Thank you very much. So the question is, in your opinion, to what extent does the principle of equality influence and shape the jurisprudence and decision-making process of the Constitutional Tribunal of Poland?
Thank you very much for this question. The answer will be short. The principle has contributed to the Constitutional Court development for a standard for legislating and applying the law in accordance with equality and the principle of social justice. The principle of equality responds primarily to equality in social and political life. It's a principle that is not the only justification for evaluation. The reason must be indicated with a specific provision. The court adheres to the principle and very rarely rules on a breach of the principle of equality. Thank you very much.
So any other questions?
Yes, and I have a question to you. What legal measures, in your opinion, could strengthen equality within entities such as the European Union?
Thank you, Faustina. So in the view of strengthening equality in the European Union, in my opinion, several legal measures should be introduced to ensure fair treatment of all citizens, regardless of their origin or social status. One key step would be to harmonize anti-discrimination law across the EU, ensuring uniform protection, and it would be in line with Article 18 of the Treaty on the Functioning of the European Union, which prohibits discrimination on the basis of nationality. Equal representation in the EU institutions is also essential. Reforms to electoral and representation systems, particularly in the European Union and Council, could be better balance the interest of all member states by introducing proportional influence based on population size and regional equality. And finally, effective implementation would require a stronger monitoring and enforcement mechanism, the creation of new or strengthening of existing EU agencies responsible for monitoring compliance with equality-related directives, and taking corrective action would make it possible to monitoring more effectively whether member states are fulfilling their obligation under EU law. Thank you.
Thank you for your answer.
So that's all. We don't have any more questions, right? Okay, so ladies and gentlemen, as we come to the conclusion of today's debate, I would like to take a moment to reflect on what we have witnessed today. So the second part of our debate has now drawn to a close, and I would like to extend my heartfelt thanks to all the speakers from both teams and their presentation, insightful arguments, and respect for the time limits. Your commitment to excellence has truly elevated the discussion, and especially thank you goes to the head of the both teams, whose leadership the Guardians have been instrumental in preparing for this event. Your effort and dedication have not only inspired your teams, but also all of us here today, so thank you once more. Throughout this debate, we have explored profound and complex topics, from regulatory integration to equality and the foundation for cooperation. So this discussion reminded us of the importance to open dialogue, critical thinking, and collaboration in addressing global challenges. So we shouldn't have any doubts that the exchange of ideas and the perspectives here today has enriched all of us. So as we reflect on the outcome, I believe it's fair to say that in this debate we are all the winners. We live because we live with a new insights and a deeper understanding of this issue at hand. So thank you once again for today's debate.
So, ladies and gentlemen, dear audience, it was a fourth edition of our debate. I am hope that the next debate will take place in our university too. But at the moment, we have a small gift for the brave participants, brave students from the BAF group. And please, the students, come to the center of this hall. And we prepared a little bit of souvenirs.
So at first, Jovan Jovanovic. Nikolina Marasowicz. Lea Feuerbach. Weronika Pietras. Wiktoria Zwolińska. Karol Rogala.
No to jest następny. Tak.
Łukasz Sitkowski. I Faustyna Zabielska.
So, and one big applause for our speech leader, as Julia Starybrat. Julia graduated. Julia graduated our Faculty of Law Administration on my direction in the Criminal Procedure Department, and now is a doctor of students in Budapest Central European Academy. Dziękuję wszystkim bardzo, dziękuję jeszcze raz studentom, dziękuję pani profesor, pani doktor za obecność. Po polsku już powiem, debata numer 4 przechodzi do historii, zapraszamy za rok. A, zdjęcie. Julka, zdjęcie. So, family photo. Family photo.
chyba, że ją trochę wysuniemy.
No to już jak chcecie. Great.
Ale ona i tak będzie składana.
Ede.
Tutaj bardziej, bo tu...
Karol, weźmy trochę do tyłu.
We as a captain of the beautiful teams, brave teams.
Oh, I think stand sound.
Fight is just about
The team opposite team is on the left side, but in really
Trochę się
ciśnijmy się. So close, close.
Jedno takie oficjalne.
Maybe. Oh, yeah. Hey, Sławka. Thank you.
Dajesz radę.
Panie profesorze.
No.